The Bush matter?
I don't see a Bush.
There's a motion to enforce a settlement, Thomas Holsheiser versus Daniel Bush, that's on the docket.
What the hell is he talking about?
I don't think so.
Ivan, what the hell are you talking about?
You sent the docket to me. I'm sitting here reading it. 10 a.m. Holsheiser Thomas versus Daniel Bush, motion to enforce settlement.
Yeah, that's not supposed to be on my Tuesday docket, so.
Yeah, if it was civil, then Patty removed it. I don't set them.
Well, it's on there.
Well, it may have been, it's no longer.
Okay, thank you.
Okay, we are live streaming. Shannon put us on the record. Okay, Tristan Miller. I see Ms. Turner. Let me let her in.
She's got a private attorney too, Mr. Lenthal, I believe is his name.
Yeah, I saw that. Let me, different name, but. And let's see, Deborah Hines, let me let her in. Okay, and hold on, let me make sure. Pretty sure I saw Robert Miller in here earlier. Yes, there he is. Okay, well, this is the matter of Tristan Miller. Ivan Brown is the LGAL. Also present in the Zoom hearing are Dejana Turner, Robert Miller, and Ms. Turner's counsel. Could you state your appearance, please?
Good morning, Your Honor. Navjot Francis on behalf of Ms. Turner, standing in for her
Shannon,
for the record.
Francis?
Last name Francis, first name Navjyot.
I'm just gonna put N on that. Thank you.
Okay. Mr. Way for the petitioner. And who represents Mr. Miller?
He's not respondent.
Oh, non-respondent. Okay, so Mr. Brown, how's Tristan doing?
I spoke with Mr. Miller several times. Tristan's doing very well. Mr. Miller has the support of his. I'm in agreement with the recommendation set forth that a custody order enter, giving Mr. Miller legal and physical custody of the minor child. I don't think Mr. Miller, there's no open custody case at this point. I would ask that the court for expediency, I don't think Mr. Miller has the means at this point to hire an attorney and go through the process of a file, that the court do what we've done in the past, initiate an order for the clerk, open a file, and then issue an ex parte order in this matter. Thank you.
So, Ms. Francis, let me explain. I often do this in neglect cases where I've got a fit parent who's providing well for the child and another parent who's slow to the process and not making good progress. I'll often enter an ex parte temporary order. The non-custodial parent then, of course, has the ability to object to that order, in which case they would get a full opportunity to be heard. If there is no objection, then the temporary order, in fact, becomes a final custody order until circumstances change.
And I believe we were in consent with a temporary order, Your Honor.
Okay, well, that sounds like that's a good plan going forward then. I will initiate opening the file and enter that temporary order. Typically, what the temporary order provides, either, it just depends on the level of engagement. Mr. Miller, do you believe that Ms. Turner would be appropriate for at least supervised parenting time?
And may I speak?
Yes.
And to be honest, you said, no, I think it should all be supervised. Everything should be supervised. And to be honest, I don't think she's been making too much progress. I think she could be giving more of an effort. She giving like the real minimum.
So in this circumstance, based on what you're telling me, I would enter an order that would provide that you have sole legal and physical custody, and that Ms. Turner has supervised parenting time at such times and with such supervisors as the parties can agree upon. And in the event that they can't agree, she can always file a petition to modify that, but it would only be modified after a hearing by the court. That sound acceptable to you?
Judge, I mean, it sound acceptable, Judge. Anything that you say, it's acceptable. It's just, me being a full-time parent, have taken care of my responsibilities, and then she can do it for like an hour a week, which she feel like it, and then half the time she don't go. It just sometimes because it be half the visits she don't attend. So sometimes I might have my son ready, and might have him in the car, then they might text me 15 minutes and before the visit and say, and she canceled. So sometimes it just be kind of irritating me, Judge. I mean, she's not trying. It don't seem like to me.
And Mr. Miller, if she persists in that kind of behavior, I would advise you to withhold parenting time. Make sure she understands that if there's going to be a regular scheduled parenting time, that she has to abide by the schedule. I realize the frustration for a custodial parent preparing for a parenting time that doesn't happen. I also realize the frustration for the child. In this case, Tristan's not all that old, so I'm not sure the extent to which he would be impacted by a no-show, but I do understand as children get older and non-custodial parents, the kid's primed for a visit, looking forward to see a parent, and then the parent repeatedly doesn't show, that creates hardship for the child and also hardship for you. So we'll give her the opportunity for supervised visits, but she has to be consistent with whatever schedule it is. If she doesn't, then stop doing it. And then the only way she could get a visit would be to petition the court, and then you both have an opportunity to explain to the judge what you think should happen going forward.
That sounds fair, Judge.
Okay, right now, well, let me ask Ms. Hines, does this sound like an appropriate course of proceeding to you?
Yes, Your Honor. And I will meet for both of them.
All right, Ms. Hines, your connection isn't very good. You're breaking up quite badly. We cannot understand what you're saying.
I tried. I don't know if you can hear me any better now, but
A little
I was
better.
just saying it sounds acceptable. The agency is in agreement. I will meet with both parents to talk about the expectations for parenting time and how that will look through front of the board.
Okay, very good. I will provide for a custody order to enter. As soon as an order is entered, the case will close. I will give you a review hearing date just in case we run into snags. That will be November 3 at 8:45 a.m. Anything else the court needs to address today?
Excuse me, Judge, may I speak?
You may.
Okay, okay, Judge. You said it's November 3rd.
Yes, November 3 at 8:45, but that will only be if we run into a snag with the custody order. Once the
Okay.
custody order enters, I will just dismiss this case.
Okay, thanks, Judge.
You're welcome. That concludes our hearing. Everyone have a good day.
Your Honor.
Thank you, Judge.
Okay, next up is King Hamby. Mr. Brown is LGAL. Mr. Wade
No.
for the petitioner.
I
You're
represent mom.
I'm
Oh,
LGAL, Your
it's
Honor.
got-
Rebecca.
It's got your name written in the jacket. You must have been an LGAL at some point in the past.
No. Whose handwriting is it?
I don't recognize it.
Probably
Someone
yours.
downstairs probably. No, it's legible, so that can't be.
I think Mr.
That
Brown
can't be
thought
true.
if he just changed the names, he could get a different role.
Okay, so I need to let Kimberly Erickson in the room, along with, let's see what we got. Kimberly Erickson's present.
Good morning.
And nobody else in the waiting room other than some other workers. So, and I'm sorry, Mr. Brown, who do you represent?
Miss Amby Way.
Objection.
So, Ms. McCluskey, how is King doing?
Your Honor, I just received info for his change placement. I reached out, was unable to reach her. I was not able to speak with his new placement. I have reviewed the court report. I have no objection to that move, obviously, and I have no objection to the recommendations. Thank you.
Ms. Erickson, maybe you could enlighten us as to how King is doing.
Yes, he's doing well so far. He has a good attachment with his great-grandmother. When he was first brought into care, he was placed with her. And I'm sure as you read in the court report, it was in the best interest to move him there for his safety and for the safety of Kadana and her family as well. So he's adjusted well. They reported he sometimes has difficulty listening, but overall is doing well there.
All right, and I realize this case hasn't been opened, it looks like a little over 6 months, or maybe about 6 months. This level of progress doesn't give me much hope that we're going to reach reunification. I would probably be looking at a goal change at our next review hearing if there isn't a dramatic turnaround in engagement. I see we still have a putative father listed. Has any headway been made on that?
No, I have not made any attempts to contact him. The CPS worker did during the investigation, and she did not have any progress with making contact with him.
Mr. Brown, do you have a position on the recommendations?
Judge, the recommendations appear to be fair. And just for briefly, Miss Hamby does quite well when she has her shot. As she did extremely well when this case was open a year or two ago. I'm confident if somehow we can get her to Lifeways to get her medication and that shot, there will be a dramatic turnaround. And I don't know how we get her there. Thank you.
She needs to cooperate. Without her cooperation, we can't help her. And the goal is still reunification. The goal is to help her. But she's got to make herself available.
With her disease, it makes it very hard to get voluntary cooperation.
But absent her being a danger to herself or others, I can't put her into custody and mandate treatment for her. I can only order it as a condition to being reunified with her children. And if she doesn't go along with it, we don't have any other tools at our disposal that I'm aware of.
Order a shot.
I don't think I can, Mr. Brown. I can order her to obtain the necessary treatment, but I don't think I can force her in a neglect proceeding to get a shot. I mean, that's why we have protected persons hearings that your partner does all the time. I think if he heard you say that, he'd probably cringe.
I have a different hat today. I'm doing what's best for my client.
I'm happy to include in my order that the mother submit to mental health treatment and care. Beyond that, I don't think I have the ability to force her to do that. Okay, next review hearing, November 3 at 8:45. Thank you.
Thank you, Your Honor.
And let's see, Riker and Remington Lewis. Looks like Mr. Brown's the LGAL. Beth Tennant, I'll let her in the room. Mr. Way for the petitioner. And let's see, who's
Your Honor, I represent Mom.
Rebecca McCluskey for Jonathan Lewis.
Beth Tennant with Family Service and Children's Aid.
Mr. Brown? How are Riker and Remington?
Extremely well. They're with their grandparents. And I've never had a concern about the placement of these two children. It seems to be that the parents are doing pretty good. The only fault that the grandparents have is that they're not totally consistent with their unsupervised parenting time. And I inquired further. The grandmother is not hesitant whatsoever that if her child or her grandchild is not doing what they're supposed to do, they're not going to sugarcoat things with me or the worker. So I tried to clarify that a little more. And what they said is that Dakota works long hours and that they've had some transportation issues. So that wasn't quite spelled out in the report. But the grandmother did say that she goes, when they do have parenting time, which is more regular than not, that the parents are extremely good with the children and do extremely well. So that gave me a good feeling that she told me that. So I'm in agreement with the plan from Ms. Tennant and ask the court to adopt it. Thank you.
Mr. Kelly, do you have a position on the recommendations?
Your Honor, I usually am able to talk with my client. Unfortunately, she didn't return my call, but I would agree with the guardian's assessment of the parents' participation in their bond with the child. So I'd have no objections.
Ms. McCluskey?
I also appreciate Mr. Brown's comments, and we have no objection to the recommendations. Thank you.
And Ms. Tennant, you are still recommending that the court grant discretion for a return home as soon as FRP services are in place?
Correct. Yes.
Okay, I will order that. We'll set our next review hearing for November 3 at 8:45.
Thank you.
Thank you all. And let's see, last one for this morning is Dakota Johnson. Like Mr. Brown is our LGAL, Mr. Way for the petitioner. Who represents the parents?
Mike Kelly on behalf of the mother.
Rebecca McCluskey for Ronnie Johnson.
So, Mr. Brown, how is Dakota?
Very well. He is placed with the maternal grandmother who has custody of several other of the children of mom out of Calhoun County. An adoption is occurring this week in Calhoun County with several other children. Maternal grandmother says that Dakota's reaching all his milestones. So things are going quite well. She is still concerned with her daughter and her significant other, how they're progressing, that things aren't going terribly well. But as far as displacement, I have no concerns. Thank you.
And Ms. Johnson, do you have any update to your report or your recommendations?
No.
Ms. McCluskey, do you have a position on the recommendations?
Your Honor, I would just state that as a correction to the court report, I spoke with my client and the court report references some missed screens, and he did state that he's in contact with Ms. Jennings and he calls in every day for his screens, but some of them he was excused from because of health condition makes him high risk for COVID. So I don't know if Ms. Jennings would want to weigh in on that, but that's what he's indicating to me. And then I guess I don't see it. We would just object to a separate domestic violence therapist or therapy. My client also indicated to me that the provider that the agency just referred the parties to for domestic violence counseling actually stated that she preferred not to do the counseling because she feels that the subject matter is being addressed through Lifeways, so it would be redundant. And again, if Ms. Jennings wants to weigh in on that, so we would just object to a second provider providing domestic violence counseling. Other than that, no objection to the remaining recommendations.
So, Ms. Johnson,
Thank
if domestic violence is being addressed through the other counseling, is there a separate need for for it?
We can get, talk to that therapist and find out if they're in agreement that they're addressing it separately. If he's uncomfortable with sharing a therapist or having the same therapist, or if the therapist is uncomfortable with treating both of them, we can find another domestic violence therapist as well. But we will
All
check
right,
it out.
as long as it's being addressed, I agree that there shouldn't be redundancy, but it's very important that it does get addressed.
Yes.
And Mr. Kelly, you have a position on the recommendations.
I haven't been able to reach my client, Your Honor. Hopefully she gets more consistent with her appointments with the therapy and with the screens. Otherwise, I'd have no comment.
Okay, I will implement these recommendations with the clarification as to the domestic violence counseling. And we'll set our next review hearing for November 3 at 9 a.m.
Thank you.
I've got somebody in the waiting room, Breezy. Is that a parent?
Don't know that.
That's Ronnie Johnson.
I'm sorry?
That's Dakota's dad.
That's Dakota's what?
Dad.
Oh, okay. I just happened to notice he arrived late. As soon as I have an audio connection, we'll make sure that he gets a chance to address the court. We're having trouble getting an audio connection with Mr. Johnson. Okay, Mr. Johnson, can you hear me?
Yes, sir.
Okay, I didn't notice you weren't present when I started the hearing, and I didn't happen to notice that you had called in. We are about done. Did you get a copy of the court report?
Yes, sir, I did. I'm sorry about that. I had to run in town. I didn't know my phone got shut off this morning.
All right, that's no problem. I have implemented the recommendations as stated with the qualification that separate domestic violence counseling won't be required as long as it's being addressed through current therapy.
Okay, that's fine. Thank you, sir.
All right. Did you have any questions for me?
I just have a question. So with me not having, I'm sorry if I'm talking loud. With me not having transportation issues, with me not having a car right now, and I call Joy Jennings all the time, my caseworker, and I report to her every day. And I told her that I wasn't able to make it to Jackson and drop in where I've been outside and I've been around people and stuff. Like I went and had my COVID-19 testing done. So I'm like, yeah, like, so that's why I haven't been able to get to Jackson and do my drug test, but I do call Joy every day and I do tell her that I do, you know, if I had to drop and if I don't.
Okay, well, thank you for that information. I've set our next review hearing for November 3 at 9 a.m.
Okay, if you don't mind my asking, so everything's going fine so far with Dakota?
Progress is being made.
Okay.
As long as you continue to engage fully in service, we are still working towards the ultimate goal of reunification with Dakota.
Okay. Yeah, I reported back to Joy that I did the housing, Jackson Housing Commission, and I and everything else, and just waiting to hear back from them. So as soon as I know from them, I can let you know about housing for Dakota when I get a car.
Just stay in contact with the worker and with your attorney and keep them apprised of your progress.
Yes, sir, definitely will. I'm doing pretty good so far.
All right, well, keep at it. That concludes our hearing. We'll be back on at 1 o'clock this afternoon. Thank you all.
Thank you, sir. Have a good day.